Hello, everyone. My name is Brenda Lee Johnson, and I am a director in the Office of Gift Planning at the University of Chicago. Our executive director, Denise Chang-Gans, could not be here, so I am happy to be moderating in her place. We've had an incredible response to this webinar, and we're thrilled to know that you Chicago alumni and friends are looking to us as a resource. This program, however, should not be relied upon as legal or tax advice, but we hope you will learn something that will be useful for you. As always, please consult your own advisors for advice specific to you and your situation. It is now my pleasure to introduce the speaker of today's program, Kim Kamin. Kim Kamin, JD 97, is a partner at Gresham Partners, which is an independent wealth management firm serving approximately 110 families nationally. Previously, Kim was a trust and estates partner in the private clients group of a large law firm for many years. At Gresham, Kim serves as Chief Wealth Strategist, leading the development and implementation of estate, wealth transfer, philanthropic, educational, and fiduciary planning activities. Kim is also an adjunct professor at Northwestern University Law School and teaches at the University of Chicago Booth School of Business Executive Education. And she is on the Founders Committee for the University of Chicago Center of Law and Finance. Kim is a regent for the American College of Trust and Estate Council, on the editorial advisory board of Trust and Estates magazine, and on the advisory board and leaders council of the Ultra High Net Worth Institute. Kim has received numerous professional awards, speaks nationally, and has written extensively on wealth transfer planning topics, and co-edits and co-authors the Limeberg Library book on estate planning for modern families, which forms the basis for her discussion today. I now turn the virtual podium over to you, Kim, whenever you're ready.
Thank you very much, Brenda Lee. It is an absolute pleasure to be here today for this. I am always tremendously proud of my affiliations with the University of Chicago, both as an involved alum and also teaching at Gleacher. U of C is an incredibly special academic community, and I'm particularly grateful for the diversity and friendships I've made through the school. Lately, I've also enjoyed my involvement with the new Center for Law and Finance and my 25th law school reunion earlier this month. I was actually back on campus just this Monday in Hyde Park on Monday evening because my former classmate, Lisa Monaco, who is now the US Deputy Attorney General, was speaking there. And I must say the undergrads, law students, and public policy grad students in the audience all blew me away with their thoughtful and insightful questions. So as Brenda Lee mentioned, my comments today are based on the third edition of our book. The premise of the book is that the modern family comes in a wide variety of configurations with members who have special characteristics and confront contemporary issues and challenges for particularly estate planning. My goal today is to give you some considerations for you to think about and discuss with your family in the estate planning arena. So let's begin with the traditional nuclear family. And when we think of the traditional nuclear family, perhaps what comes to mind is the Cleaver family from Leave It to Beaver that ran from 1957 to 1963. While certainly during that time frame, there were a lot of families that didn't look like this. The ideal of family was certainly epitomized and portrayed by what was seen on television. And this family was a husband and wife, a male and female, who married young. They were expected to stay married. In fact, from 1950 to 1970, the median age of marriage was around 20 years old. They were expected to have 2-something children. The average number of children per married couple in 1965 was exactly 2.5 children. They had traditional gender roles. The men handled the finances. At least 50% of mothers didn't work outside the home. The assumption, importantly, was that the children would then repeat the pattern, which impacted how estate plans were designed. But much has changed. First, evolving social norms and social changes, things like delaying marriage. The average age of marriage now is closer to 30 for both men and women, then divorce, remarriage, blended families, unmarried cohabitation, which is on the rise, long-term couples who don't want to marry, social norms and changes with same-sex couples, the views on LGBTQIA+ individuals has changed dramatically in the past 20 years, also going solo and single parents by choice, changes in gender roles. Now at least 70% of mothers do work outside of the home. So those are some evolving social norms we'll talk about. Now, corresponding to these evolving to these changing social norms, we've also seen evolving laws that mirror those changes. So for example, the creation of civil unions and domestic partnerships that were enacted to protect same-sex couples and are still available in some states. And then same-sex marriage, which since 2015 has now been legally recognized in all 50 of our states. Inheritance rights for children and family members who are adopted. These are also very different today legally than they used to be. And correspondingly, rights for non-marital children have also changed legally. I will just also note that the tax laws have changed significantly over the years as well. And for families who have significant assets, they can now shelter over $12 million each from transfer taxes under the current rules. Then in addition to the evolving laws, we've finally seen changes in medical and technological advances that lead to things like longer lifespans, the creation of new asset classes, digital assets, cryptocurrencies, and also in the area of assisted reproductive technology, cloning technology, and other anticipated technological advances. So these are now all the backdrop for looking at the modern family, which is depicted on television now in a very diverse way. You know, I would say if Leave It to Beaver was the traditional nuclear family, then today's modern family began to be epitomized by the award-winning show of the same name that ran starting in 2009 and ending in 2019. You know, classic blended family. There was also a daughter who was a stay-at-home mom and then later took over running the family business. We saw an international marriage for the patriarch. We saw a son who was gay, and we saw the evolution for him with his same-sex partner as they adopted internationally and then eventually were able to marry under California law. So there really was a lot of change that was reflected in this show. But then there are many other shows since then as well. This is a screenshot of Jane the Virgin, which was a telenovela where we saw Spanish-speaking family members and the storyline of a non-citizen abuela, children from assisted reproductive technologies, gay characters and exploring their relationships, and even a character who came back from the dead. That show also ended. But today, TV continues to show us and reflect the incredible diversity in the modern family. So what are our topics that we're going to try to cover? I'm going to hit on each of these topics very, very quickly, given our limited time. The book itself has about 20 chapters, each on a different topic. And talking about best practices and drafting for flexibility with all modern families. But today we're going to hit on each of the topics that you see up on your screen, and some of which I alluded to a moment ago. And importantly, my hope is that while some of the things that we touch upon might not apply to your particular family, hopefully there will be enough in here that you will have things to think about with your family. There'll be something for everybody as I just drop a couple of nuggets. So first, let's look at marital status. Legally, there may only be 4 categories, but in reality, there are many more variations of those relationship themes. For example, we will talk about divorce, going solo, unmarried couples, same-sex married couples, remarriage and blended families, polyamorous relationships, and multinational couples. I recognize there's a lot here, so again, I will be brief, and thankfully I talk pretty quickly. If you're listening to a recording of this, you can slow me down if it's too fast for you. All right, let's think first about divorce. So every 30 seconds, there is a divorce in America, and we've all heard the statistics that about 50% of marriages end in divorce. The reality is that divorce peaked. These rates peaked in the 1980s, but there are trends that are noteworthy. For example, gray divorce of those who are over 50 have doubled, and those who are divorcing over the age of 65 has tripled. We've also seen reports of COVID increases. There was a 21% increase in filed divorces in 2021 over those filed in 2020. But the rates are still about 50% of annual marriages. But the statistics are done in different ways. So, and they have been declining down in some reports down to 40%. And there's also reports that college-educated women are significantly much less likely to divorce, and those numbers are about 20%. There was an article in the New York Times a number of years ago that I loved that was entitled "How Divorce Lost Its Groove," that focused on how the divorce rates really have been going down since the 1980s. The other trends in divorce for you to think about with your family is that there's a trend towards good karma divorces and collaborative divorces and nesting, where the parents may share the same home to keep things consistent for the children. So many of our preconceived notion about what divorce needs to look like as the War of the Roses is no longer applicable. So we want to keep that in mind with estate planning, that there are lots of different kinds of divorces. There's also a trend towards high net worth families who are in long-term separations and never divorce that we'll talk about in a few more slides. My advice when you're thinking about drafting for divorce, as I said, because there's so many different types of divorce, is work with your attorneys to use a scalpel rather than a machete approach. For example, defining that a spouse is immediately deceased for all purposes upon the filing of a divorce action can be very extreme in how it impacts the estate plan. So it might be a more cautious and careful approach to simply enable somebody who could remove the spouse as a fiduciary or exercise powers of appointment to remove them as a beneficiary upon an actual divorce. Another trend, going solo. We have up here a picture of my friend Eric Kleinenberg, who's a sociologist at NYU, who wrote a book called Going Solo, The Extraordinary Rise and Surprising Appeal of Living Alone. When he set out to do this research, he thought it was going to be a very sad story of people living alone. What he found was that in affluent societies like ours, where people can live alone, meaning that they are unmarried because they're divorced, widowed, have decided not to marry, or are still searching, but those numbers go up precipitously and oftentimes are intentional. People enjoy living alone and building community with friends and neighbors. But there are some estate planning considerations if this is you. or someone in your family. If you are a single client without children, you'll need to be very clear about what your testamentary wishes are. If the default plan is that things go to a spouse and to children, so you need to think about who inherits your property and recognize that sometimes it can be a lot more expensive for you to draft a plan than for somebody who does have a spouse and children. And also for many of our single clients, we see that they have fur babies instead of human babies. And so pet trusts tend to be of significant interest to these types of clients. Also, single parents, especially single parents by choice, as I referenced. These numbers have oh, I'm sorry, just a quick number. I'm going so low. I referenced how much it's increased. It's actually more than doubled since the 1950s. It's gone from 20% of Americans living alone to over 70%. So that's a huge increase of single clients. Moving on to the single parents and single parents by choice, the percentage of children in only one parent households has also more than doubled since 1960. It's gone from 10% to about 25% of children are living in a one parent household. And then I referenced single parents by choice. We've seen single mothers by choice who are choosing to have children without a life partner. High net worth fathers have also joined this trend. When I last checked, it was about 16% of single parents were fathers. But here again, there's some special planning challenges. If you are the only parent, you need to make sure that there are temporary standby guardians if the parent is unavailable because they're traveling for work or on an airplane and leaving their children with someone else who will need to have legal authority to sign permission slips or to make important medical decisions. Permanent successor guardian decisions also become much more important. When a child has other parents, presumably that parent or other parents would become the successor guardians. But when you are a single parent, then naming a guardian in case something happens to you is incredibly important. Also making sure there's sufficient life insurance to support those children, or that you have other assets that will get them through their lifetime if you are the only person who is providing for their financial well-being. And then again, the selection of agents and trustees when you are single is even more important than when you're not just simply naming a spouse or adult children. Also, unmarried couples is a trend in modern families. This is a really big deal from a planning perspective, because if you are unmarried, you cannot take advantage of the unlimited marital deduction that those who are married can in leaving assets to a partner. The first thing to do is figure out what is your actual status. Depending on your state, it could be that you're in a common law marriage and don't even know it. Or you could, as I referenced earlier, be in a civil union or a domestic partnership that will infer some or all of the benefits of marriage, aside from the federal tax benefits. Need to think about the planning aspects of how to provide for your unmarried partner. And because you can't just pass gifts back and forth to each other because there's no unlimited marital deduction, the accounting of running your household becomes incredibly complicated. It's very helpful if you can have a cohabitation agreement that sets forth your rights and responsibilities and expectations, both during the relationship or upon separation or death. And also there are alternatives to cohabitation agreements, like titling assets in a trust together, a joint trust of some sort, or an LLC or partnership. Moving on to same-sex married couples, as I mentioned, ever since the Obergefell case in 2015, in theory, same-sex married couples in our country should be treated just the same as other married couples. But as we've seen, in the headlines over the past 4 to 6 years, same-sex couples who are married in our country do still face some issues. We saw the Colorado case or the Georgia adoption case, and we do need to take extra steps to make sure that those of you who are in same-sex married couples do carry around, for example, proof of relationships and authority, your powers of attorney, and marriage certificates and other documents. It's a good idea to have those handy on your phone in case you need them. And you do still need to be concerned about international travel, because you may be traveling to other countries that do not extend and afford to you the same rights. All right. Moving on to blended families, remarriage, comes with, after divorce, oftentimes that comes with remarriage, but that sometimes comes with children who do not share all the same parents. So remarriage is really all about balancing issues, balancing the interests of these various stakeholders. It can add complexity to the dynamics. They're the classic conflicts that we see here up on the slide, and I'm sure you're well aware of. One idea of these conflicts, the one that we're most concerned about is the current spouse with children from prior relationships. So one idea is that if there will be conflict between those parties, that maybe setting up a marital trust for the surviving spouse that names the children and descendants from prior relationships as beneficiaries could cause unnecessary conflict. So one alternative might be to name a charity as the remainder beneficiary at the surviving spouse's death, and then perhaps to give them a power of appointment so they could add back your children from prior relationships if they wanted to, but that tilts the balance of power so that there is not an expectation. Corresponding to that, you would want to give your children from prior relationships some assets at your death, contemplating that those are the only assets they might ever receive if the surviving spouse chooses to either spend all the assets or not exercise that power of appointment to divert assets away from charity and to the children. Moving on now to polyamory. This was a new chapter that we added in the new edition of our book, based on questions that I was getting from advisors who were wondering about their clients who were in polygamous relationships. Now, it took me a minute to understand what they meant, because these are not clients who are in polygamous relationships. Polygamy is illegal in our country still. But polyamory is, going mainstream and has been a growing trend and is appealing for many individuals and families. It's really just those who are in a committed relationship with more than one partner. They might be legally married to one of those partners and not legally married to the other partner. But as you can imagine, being in polyamorous relationships also requires some very careful estate planning. We do see, as in the picture of Warren Buffett, and as I referenced earlier, that oftentimes polyamorous relationships occur because someone who's in a long-term marriage does not want to divorce their spouse for many reasons, and they're on good terms, but is now in a relationship with someone else who needs to be provided for. Again, won't be able to use the unlimited marital deduction for that non-marital partner, so will require some very careful planning, oftentimes insurance policies to provide for their well-being, transfer on death accounts, perhaps. There's special considerations there that you'll want to think about. And we do see a tremendous increase in polyamory showing up in the media. We saw it not only in Big Love or in Sister Wives, which was the Utah version of polyamory that may in fact be referred to polygamy informally, but we've seen thruples in The Politician, like what you see up on screen, a show called American Princess that featured a thruple. For those of you who've seen the sequel to The Fosters, Good Trouble, they also have polyamorous themes. So it really, and the Smith family, of course, we've all seen in the media. So really, polyamory is here to stay. It's gone mainstream, and we need to think about it for our family members who may be in those relationships, or for any of you who might be. Moving on to multinational couples, this is the final consideration. Multinational families are very common. The recent data shows about 20% have at least one foreign-born spouse, and about 5 to 6% of US citizens are married to non-citizens. A few considerations to think about here. There also is no unlimited marital deduction for a non-citizen spouse. Annual gifts are limited to only 159. Oh, sorry, these were last year's statistics. It's 159,000 in 2021, and I don't have it in front of me, but I think it went up to about 162,000 for 2022. Other things are to consider using qualified domestic trust, because you can't use what's known as a Q-tip trust as the standard marital trust. So want to be attuned to that, and also want to be attuned for multinational couples to avoid creating a foreign trust by naming a non-resident or non-citizen as a fiduciary in the trust. So some things to think about there. And now moving on, let's talk about defining descendants and how clients' descendants are both defined and determined. So we're going to shift gears and move into this section. Who is included in the definition of a descendant? What are the different buckets of the types of descendants? So here again, I'm setting forth a short list of the types of categories that may fit into the definition of descendants in an estate plan. And I have a slide on each of these in this section, and then we'll talk about posthumous children when we talk about technology and assisted reproductive technologies. So first, let's think about stepchildren. There's not a lot to say about stepchildren. I had a slide earlier about blended families where it talks about these tensions with blended families, with biological children and stepchildren and children who may have been adopted that were stepchildren. But it is important to think about, what are the relationships like here? Where are the tensions? Where are the conflicts? What is the intention? Do you intend to treat stepchildren, even if they have not been formally adopted, as children for multiple purposes under the estate plan or not? These definitions and the specifications that you tell to your lawyer will be very important in that regard. Another consideration is that oftentimes people would want to adopt their stepchildren, but they cannot do so until those stepchildren have turned 18 if they already have a living parent who has parental rights that are not going to be terminated. So when drafting documents that contemplate adoption of stepchildren, it is a great idea to make sure that adult adoption, at least up to the age of 21, is permissible to give those families a little bit of time to adopt the child. Which is a nice segue into thinking about adoption. So the statistics are that about 4% of U.S. families do have at least one child who has been adopted. And the types of adoptions that you might see are minor adoptions, international adoptions, which were incredibly trendy for many years. You see here a picture of Angelina Jolie with many of her children who were adopted. The numbers actually quadrupled of international adoptions between 1982 and 2004, but then many of the rules changed to make it stricter and more difficult to adopt internationally, and so those numbers have really plummeted since then. But you may be interested in international adoption and of course need to work with specialists who can help you accomplish that. There's also surrogacy adoptions, informal or equitable adoptions, which are not done through a formal adoption process. It's documentation for some states that will recognize equitable adoptions. Legally, there have been lots of historical changes. 50 years ago, there was something called the stranger to the adoption rule, where if you adopted a child, that child could inherit from you, but could not inherit from your parents or from other family members. They weren't treated as a true descendant for all purposes legally. That has changed significantly, and states now do give children who have been adopted the same rights as descendants as other children. In fact, there was a recent case last year where someone in their document, I believe it was in Kentucky, tried to exclude all adopted persons and their ancestors and their descendants from an estate plan, and that was deemed void against public policy to try to exclude that entire class of persons. So there is recognition that while a client might be entitled to disinherit a particular person who has been adopted, you have to be really careful about class gifts. Also important to think about the impact of prior documents. If you're working with family documents that are older, there may be references that exclude family members who are adopted that you want to try to address or work around to the extent that you can. But ordinarily, in working with families who have children who are adopted, it's a good idea to know if those children are adopted, but in the plan itself, it's best. There's no reason to be distinguishing between biological children and children who are adopted unless someone was trying to be discriminatory against them. Moving on to non-marital children, I used to have a picture of Jon Snow from Game of Thrones up on this slide for those of you who were Game of Thrones fans. That he turned out to not be a non-marital child. But here are some famous ones: Alexander Hamilton, Eva Perón, and even Leonardo da Vinci. Here again, language matters. You might have older documents or be talking to people or looking at old state statutes that talk about children who are illegitimate or out of wedlock. We try to encourage everyone to just recognize that the category and description for children who are not married, who are not born to two married parents, are merely non-marital children. In 1960s, the numbers of non-marital children were about 3.8% recognized. It's now up to 40%, and in some states like Mississippi and Louisiana, it's up to 55% of children born each year are born outside of having two married parents. Intestacy here again used to exclude non-marital children from inheriting, but like with the adoption rules, this has changed. On the estate planning side, need to think about how to define non-marital children and whether they will be included or not. Do you require DNA tests? Do you require functions as a parent tests? There are, a number of different, is there a hybrid? There are a number of different ways to actually define and include non-marital children or exclude them when not intended. Moving on to planning for diversity. This section just focuses on other forms of diversity that we see in families. Certainly the last couple of years have been transformational in terms of DEI awareness, and this is not just societal and in the workplace, but it is also important to consider in the context of families. So here are a few special considerations for diversity. The first is family members who have disabilities or special needs. According to the CDC, approximately 53 million adults, 1 in 5, are living with some kind of disability with longer lifespans. We've seen Alzheimer's deaths rising, and they're projected to rise more. We've seen a rise of autism. We've seen a rise of Down syndrome. We've seen many other forms of disability. We've seen practitioners and families struggling with language, differently abled or disabled, and people have their own views, but being sensitive to language is one of the themes of the book and of this talk today is really, as I said, children who are adopted, but rather than adopted children, non-marital children, and again, in a particular family, people might like to use different language to describe their family members who might have special needs. The key here is to make sure that the plan is drafted so that you do not disqualify family members who could qualify to receive governmental benefits if they need them from those benefits. So it's important to have magic language in your documents that says that the assets in the trust can be used to supplement but not supplant any governmental benefits to which the beneficiary might be entitled. There are lots of individual rules. It's important to be working with a specialist who focuses on planning for special needs when you are doing that planning. Moving on to LGBTQIA family members, this refers to lesbian, gay, bisexual, transgender, queer, intersex, asexual, and then the pluses for any other identities. Some of these labels are about sexual orientation, and others are just about gender identity. Being transgender or non-binary, really is not about sexual orientation at all. It's about identity. And certainly we've seen a huge increase in transgender family members, including at very young ages. That needs to be considered in planning. As we've said, the new question when someone's pregnant with a baby and everyone says, "Oh, is it a boy or a girl?" Or they're strolling around their baby, "Is it a boy or a girl?" It's like, well, we don't know if it's one, both, or either until they can talk and tell us themselves. So things really have changed significantly in that. Similarly with estate planning, it's important to try to be using non-gendered language to recognize that your granddaughter may be in a few years your grandson, or maybe non-binary. So it's just, and their names can change. So the more that the documents can refer to children and descendants, or to grandchildren specifically, without requiring those labels, the happier people will be later when those documents don't need to be restated to accommodate them. We've also seen changes with racial and cultural diversity. 1970 to 2008, interracial couples went from fewer than 1% to almost 4%. When I started this research, about 7% of couples were interracial, and that grew from about 7.4% in 2000 to more than 10% by 2016. And I will say the most recent estimate I saw was that almost 20% of all new marriages are interracial. Obviously here there's no legal differences, but for your family to talk about these cultural differences and race as an issue is important to do. What are the family expectations? These can be really charged times, and we hope our family members will be sensitive to other family members and what their needs are. It might be appropriate for the family to have a book club and read anti-bias materials together, and think about how language can be landmines. Finally, religious diversity. This is really important on the estate planning and the family side for things like wedding ceremonies, holidays, cremation and burial, Sharia law if there's forced heirship, Orthodox Jewish rules. And sometimes the family's trust may still try to discriminate and require family members to marry within the faith. There are ways that have been deemed void against public policy to attempt to do that. And there are certain other ways to frame that where there could be some added benefits to family members who do marry within the faith. So that has to be navigated very carefully. On the philanthropic side, it also impacts how clients give and perhaps how much they give. If they're following, tithing, which requires 10%. Judaism has tzedakah, which is also supposed to require 10% of donations each year. Then in Islam, there's also different types of donations. So this can impact charitable giving as well. Moving on to technology, modern families have modern assets. They have digital assets, they have genetic material, and then there's the anticipation of future technology that can impact families in the future even further. A couple of very high level points that I'm going to race through. First is digital assets and cryptocurrencies. This is all of the contents that you have on any of your devices, your computers, your phones, your tablets, items in the cloud like photos, music, emails, Kindle books, online accounts, your financial accounts, your social media accounts, the currency that you might have, Bitcoin, non-fungible tokens. The concerns are that unless your estate plan specifically grants your fiduciary full access to these assets, there will be very limited access after you are gone. So as part of your estate plan, you want to really think about how to grant access to these assets so that your family members or other named fiduciaries can step in for you. And there's also privacy settings for some of the social media accounts. You might not want your fiduciaries to see them, so you need to go into those accounts and elect what happens when you're gone. Is everything erased? Can they disclose it? Maybe not to your fiduciary, but to somebody else. It's important for you to think about this. Also assisted reproductive technologies, ART for short, or ART for even shorter. Oh, sorry, I just went too quickly. You know, there's different types of assisted. I know what I did. I cut one of the slides because I knew we were going to be crunched for time. But here, there's some things to think about. You know, the types of assisted reproductive technologies are artificial insemination, in vitro fertilization, surrogacy. All of these require special contracts and special considerations. There's posthumous reduction issues. Do your trusts allow for descendants who are born after you're deceased, or for grandchildren to be born after your children are deceased? It's important to think about what you might want in that regard. At a certain point, it can be very helpful for those administering your estate to close the class of permissible beneficiaries in order to administer the state. Some states are coming up with their own laws that say they have to be in gestation at the time of death, or that they need to give notice to the fiduciary, the person who's in charge of the genetic material, that they intend to create more children or more descendants. And of course, the fear for every ultra high net worth family is that one of their descendants, partners who has access to their genetic material may be like Octomom and try to create many potential beneficiaries for the trust. So a lot of things to think about there. Moving on to cryonics and cloning. This is available. You know, cryonics is still science fiction, but it is actually a viable option for clients to determine whether they want to be buried, cremated, or frozen. The idea is that you know, like in this Vanilla Sky movie, for those of you who might have seen it, that individuals who can afford to do so can contract with a cryo company to preserve their body. But then you need to think about, or sometimes it's just the head, but you need to think about what assets are going to be available to pay for the expenses of maintaining those body parts in their frozen state. And also, if in fact there ever is an opportunity to revive that person, what assets will be available to support them? Will they be treated as themselves, even though they're a deceased person, or will they be treated as a new person, especially if perhaps the way that they were revived was via cloning? So these do come together, because a cloned individual, if there's genetic material that's available, could again be viewed as the child of the person who is deceased, or could be viewed as the person themselves. There's a lot of room here for the law to evolve on this area as the technology might evolve in this area. A lot of ethical questions too. Okay, quickly, modern philanthropy. I'm not going to spend a lot of time here, but we did add a chapter to the book about modern philanthropy this year. When the edition came out recently, the key here is that donor advised funds are, you know, the main story for modern philanthropy. That is the main charitable vehicle that is now being used for charitable giving. But there's also a host of traditional approaches like private foundations and charitable trusts. charitable annuities. So those are also methods to consider for your charitable giving. And then another trend is just in ESG and impact investing, particularly for philanthropic dollars, so that you are not trying to solve health issues with lung cancer while also investing in a tobacco company. So lots to think about there. And then finally, before we move on to questions, just a couple of comments on drafting for all modern families, for all the different types of families we've been talking about. There have been so many changes, as we've discussed, to the family and society in the past 25 or 30 years. We can only imagine what the next 25 or 30 years, let alone the next 100 years, will bring. And yet what we have seen is with the erosion of what's called the rule against perpetuities, and many states permitting dynastic trusts to last, in some cases, forever, we are seeing that you and other families are setting up trusts that can last for a very, very long time. So the point that I want to make to you for you to bring home in working with your lawyers in drafting trusts is that maximizing flexibility is a huge gift, not only to your family who will be coming after you, but even to yourself. I can't tell you how many times we've seen clients draft a trust in 2012 to quickly take advantage of the exemptions that were available then, which were much lower than they are now, and then realize, a year later that there were problems with the trust that needed to be fixed. So we do recommend that trusts be drafted with broad standards, the ability to replace trustees, the ability to have different parties holding fiduciary roles, powers of appointment, which I had referenced earlier, which gives someone as a power holder the ability to give assets to someone who is not named expressly as a trust beneficiary. There's trends towards trust protectors and decanting who can make actual edits to the document, actual modifications without having to go to court. We want people to be able to change situs and governing law. So if you set up your trust in New York, you can move it to a state like Delaware when the family is no longer in New York, or if you're setting up your trust in California, the family can move to Nevada or Texas or somewhere else. So we do like to see those provisions in there because families are mobile and live in lots of different states, and the states have lots of different rules. And then also a consideration of protecting privacy. So I went a little longer, I know, than Brenda Lee had hoped I would, but hopefully I hit on everything quickly enough. And now let me stop sharing screen and we can entertain a few questions.
Thank you so much, Kim, for some very useful information on a wide range of estate planning topics that may be relevant to us or our loved ones now or at some point in the future. So I'm going to proceed with some questions. We had quite a few questions pre-submitted to the webinar today, and we also have some that have popped up through the Q&A box. The first question is a medical power of attorney adequate for my partner and myself if we're not married? Can family members still intervene?
Okay, so quick reminder that I can't give legal advice, as you said at the beginning, and even more important caveat, which is that the laws vary significantly from state to state, as I mentioned before. So you want to always consult your attorney in your state who is practicing and licensed in your state. But with that caveat, if you have a properly executed power of attorney that wasn't procured by fraud or duress, and the power of attorney is valid under your state law, and it's very clear in naming your partner as your agent, just as your will and your trust should be very clear if you want to name your partner as executor and as trustee. In theory, and certainly in my experience, those should be honored by the medical professionals, and for the power of attorney for property, also by the financial institutions and the courts. But there is an exception that I'd like to note. We have seen over the last few years some banks and broker dealers and custodians who now have their own forms that they want you to fill out for who can speak on your behalf if you are disabled or unable to speak on your behalf. So you will want to explore with your banking institutions or whoever you're working with as a custodian if there's something in addition to the power of attorney that they want to have on file. And I would strongly recommend that you make sure everyone who could possibly be involved in your healthcare or your primary care doctor, everyone has all of the forms that you want them to have. This ties into what I was saying about unmarried couples and same-sex couples carrying documents around on their phones. Definitely make sure that you are doing the work now to make sure that the people that you need to honor these if something were to happen do, and will listen to your partner and not to your family members that you would want not to be the ones making those important decisions for you.
Certainly important at a time when it may be a little bit too busy for people to think about. Here's another question. My wife and I have a son whom I gave birth to. When he was born in 2012, we were not married. We could not marry. Later, when we were able to add my wife to his birth certificate, but she did not adopt him. Is this relationship protected with the birth certificate alone?
So same caveat as above, this varies tremendously depending. The answer to this question will depend on your state. For example, in Illinois, if you were in a civil union at the time that you were married, you could assert the same presumptions that a child that's born of the marriage belongs to both parents. If your wife is on the birth certificate, a lot of states will, view that as conclusive evidence that your spouse is the partner, is the legal parent. But a lot of practitioners do involve, nonetheless, always adopting as well as a belt and suspenders approach. Just in case, you might not want to do that for a lot of reasons. Sometimes people find it offensive, like, why would I have to adopt my own child? This is my child and I'm on the birth certificate. But out of an abundance of caution, you will in some states talk to professionals who will recommend that nonetheless. What is the risk? What are you concerned about? The risk oftentimes is really that upon divorce, that your partner would not have the same legal rights to the child and to custody and to share custody and share time with the child as you would. So the extra step of adoption is usually to preempt that. But I will say there's even cases where even if the child is not legally adopted and is not on the birth certificate, I mentioned this concept of, equitable, determining someone as an equitable parent. There are cases where children now are deemed to have even more than two parents. So if there's two biological parents and one parent who helped raise the child because they were in a same-sex partnership or a non-married partnership, or another significant relationship with the parent and helped raise the child, we've seen cases where even those parents can have access to time with the child, even without the what might look like legal parentage. So it does depend what your concerns are.
That's very helpful. Another question we received is focused on how to best structure an estate to benefit and not necessarily ruin subsequent generations. This person would like to provide moderate benefits for generations in perpetuity rather than a substantial windfall for the immediate line of beneficiaries. So Kim, do you have some thoughts about that?
I do, and that's not really a short question. We could spend an hour just talking about that. But this is the kind of question that I can answer and something I'm pretty passionate about. It will depend on the size of the estate and the composition of your family. But I will say personally that I work with the families that I like to work with to help them to raise financially savvy and independent children and grandchildren. We do not want the assets that we have been successful enough to accumulate to rob our future generations of the joys of creating their own wealth and living off of their own earned assets. And in fact, I can recommend a book by another friend of mine, Ron Lieber, who writes for the Wall Street Journal and wrote a book called The Opposite of Spoiled, which can be a really helpful guide to parents as they are thinking about what does it mean to raise children who are not spoiled and are not baby birds who are going to just always be looking to the parents and the assets that are in trust to support them rather than have them go out and support themselves. But a couple of things to think about there as well. You know, life expectancies, while in 2020 they did have a dip because of COVID, overall have been going up. So for the average American, men are living until about 76 years old, women to 81. Let's just say, the average age is about 80. That doesn't apply to high net worth families that are engaged in estate planning. The research has shown, there was a study, I think at Northwestern, maybe last year or maybe a couple of years ago, that actually I think it was last year, that helped demonstrate, as other researchers have shown, that ultra high net worth families members have better access to medical care, take better care of themselves, and tend to live about 10 years longer than the average lifespan. That's why the insurance rates for ultra high net worth families can be lower than for ordinary individuals. But so the question is, how old do you expect to be when you die and are passing these assets to your children? Oftentimes, these children are already going to be in their late 50s, be in their 60s, possibly even their 70s by the time that you actually pass, and they would have access to these assets. So you, in those cases, don't need to be worried about the assets. They're already at retirement age. And in fact, if you allow them access to those assets, they can be pretty helpful for retirement. But it's true, if you have enough assets that you can set up one of these long-term dynasty trusts that I alluded to early, that's the best way of doing it, where the dynasty trust is there, it's viewed as an emergency fund. Family members could have health problems where they really do need to live off of these trust assets. You don't want to discourage probably your family members from going into lower paying but societally beneficial professions like teaching or social work. So those assets, as long as the trusts are drafted flexibly enough, can be used for the family members who need them, but also can grow and last throughout the generations. And you can do a side letter of wishes expressing to the family what your value system is and what your intentions are.
Sounds very effective. Important to have that understanding. Here's another question. How do I set up a special needs trust as a divorced parent if the ex-spouse is not interested?
Yeah, so I did have a slide, as you saw, about planning for special needs trust, and I mentioned a couple of things there. And it is probably a good idea if you're planning for a special needs child to set up a standalone special needs trust that follows all the specific rules in your state and has all the magic language and is working with an attorney with a lot of expertise in that area. That you then can tell parents and aunts and uncles and your former spouse and others that, like, hey, I'm making things really easy for you, and your plan, please just at least give whatever share you want to go to our child to that trust. It's not going to cost you anything. And that can be really helpful, because then again, they won't be disqualified from benefits that they need. And it's actually funny, I've worked with some very wealthy families where they're like, why would I ever want my child, I'm against paying taxes and I don't want my child to be dependent on the government, and that's silly. We have plenty of resources. Why would our child ever need a special needs trust? Sometimes your child needs to qualify for Medicaid simply to have access to programs that exist. This is actually one of my soapbox issues, because I think it's so silly that there aren't self-pay options. But if you have a child who's bipolar and you want them to be living in a residential facility, you might not be able to do that with self-pay. You may need them to be impoverished in order for them to live in that facility. If you have a child who's autistic and you're trying to get them into a special educational program, you may need to impoverish that child. We've seen cases where those children might have received lawsuit proceeds that are in their own name. The good news is that even if your spouse, your former spouse, let's find the right word there, fails to do planning themselves and refuses to simply name the trust that you're setting up as the recipient of those assets. If they were to die intestate and leave the assets to pass through probate, many probate courts, certainly in my state, I don't know about all of the states, although I did see one in Maryland. I think probably in many of the states, the probate judges are very accommodating when inherited assets need to be moved over to either it would then be a self-settled special needs trust, or you would need to go to a third-party pooled special need trust provider rather than it being administered by your own third-party trust. So there would, at the child's death, need to be payback to the governmental reimbursement for certain payments that were made by the government for Medicaid. You would, if there's any assets left, you would in fact have to reimburse if you take that approach, but there are ways to at least still get them to qualify for benefits during their lifetime.
So it sounds like there is some alignment that can happen even if one party is not willing.
Yes, there are creative
ways around it.
Yeah. Creative solutions. There are creative solutions most of the time, again, working with very competent lawyers and advisors.
Kim, I'm afraid we've run out of time and we've reached the end of our program. So we thank you so much for sharing your expertise with our alumni and friends. Gives us a lot to think about. There's a lot of flexibility and fluidity involved in these things, and we appreciate you sharing that with us. And if we did not answer your question today and you'd like to continue the discussion with a member of the Office of Gift Planning, please email us at giftplan@uchicago.edu or phone our office. And we're putting this email address in the chat for your convenience, but please be on the lookout for an email with a link to the recording of this video and a short survey. As always, we invite you to visit us online and hope you'll continue to use the Office of Gift Planning as a resource for your personal planning, as well as to maximize your planned gifts to the university. Thank you again and have a wonderful rest of the day.